Some people will tell you that you don't need a trust unless you have a really high net worth.
So as my net worth increases, will it make it harder for my kids with probate and a will as opposed to a trust?
No, a will is, unless you've got a net worth in excess of $100 million, you're probably not going to have any needs for trusts. The will suffice and take care of it. So
Why would you say that? I'm just curious.
well, because a trust doesn't do anything.
Well, you can avoid probate, like what he was saying. There's some ease to it. It takes a lot of work to move everything into the trust, but
Yeah, you move everything into the trust, then you have to operate your life out of the trust, which is a pain in the butt to the point that you'll wish you had never heard
That it
of
wasn't
this on
worth
the
it.
internet, which is where you heard of it. But it's horrendous. So no one does it in the real world. The only people that talk about it are lawyers trying to sell trusts. But everybody out here in the real world, all of my friends that have 20 and 30 and $50 million net worths do not they do not operate their lives out of trust.
Meanwhile, there are other YouTube lawyers that are telling you that every American needs a trust and everything you own needs to go in it.
The Revocable Living Trust is a wonderful foundation for everybody, and I stand by it. Every American needs a trust.
Everything needs to be in your trust. Your trust is this one document in your life that needs to be comprehensive about what's going to happen when you pass on, and your trust should own everything. So we want to make sure your trust owns everything, or I'd say mostly everything.
Yep.
And if it doesn't directly own it, we had a plan for it in the trust at least.
I think that both sides are missing the actual answer. If you've watched my last video on Dave Ramsey's financial advice, which I'll link somewhere up here, you already know that I don't think that one size fits all advice serves anyone well, including my own. So today I'm walking you through several key factors that will help you determine whether a simple will cover you or if you actually need a trust. By the end of this video, you will know exactly what actionable steps you need to take next, including my free estate planning workbook, which you can download below after watching this video. And a quick disclaimer before we jump into it. Obviously, what is right for you depends on your situation and your family, but also the estate planning laws that apply in your state. In this video, I'm just walking you through general concepts that apply nationally, and I'm just touching upon some common factors and scenarios that may or may not apply to you. But there are other factors out there too, which could determine whether you need a trust or not. That's why this is just a starting point and not a substitute for sitting down with your attorney. And before we get into the examples, let's get clear on what a will and a trust actually are. A will is a simple legal document that says who gets your stuff when you die. What it doesn't do is change how your assets are titled while you are alive. So everything you own stays in your name. So whatever is still sitting in your name when you die will be frozen, and your family will have to go through probate. Probate is a court-supervised process in which the court determines what goes to who when you die. So if you have a will, the court will make sure the assets go to the people you left it to. Now, not everything you own necessarily falls into that bucket, and we'll get exactly into what accounts and assets don't need to go through probate in a minute, but at its core, a will does not retitle anything ahead of time. It just directs where things go once probate sorts that out. A revocable living trust works differently. So all your assets, including your home, your accounts, your business, get retitled into the name of the trust while you are alive. But your trust only avoids probate for what is transferred into it. If you only sign the documents and don't actually retitle anything into it, it's basically just a very expensive empty box. And even if you set up a trust, you still need to have a will. Some call it a pour-over will, and its whole job is to catch anything that didn't transfer into your trust. So this really isn't a will versus trust question. It's whether a trust on its own is enough, or if you need a trust working alongside it as well. And to make this practical, meet Sarah and Mia. Sarah's situation is pretty straightforward, while Mia's situation owns a small business. She has a little ice cream shop called Mia's Gelatos, and she has a few more moving parts that make things a little bit more complicated. So let's get into the 5 different factors that I am going to cover that determine whether you need a trust or not, and how Sarah and Mia's situation will determine that. So factor number 1, which we already touched upon, is probate exposure. The real question here is not really whether you want to avoid probate. It's how much of your estate is exposed to it in the first place. Actually, a lot of assets already avoid probate on their own. Retirement accounts and life insurance already pass to the designated beneficiaries without having to go through probate. Brokerage accounts already carry a transfer on death designation, also known as a TOD designation. And for your bank accounts, you can simply set up a payable on death designation, or POD. And depending on your state, even your car or your house can transfer upon your death without having to go through probate. There are special beneficiary designations that you can file for those. So if all your property is designated to beneficiaries ahead of time, those assets will go straight to the people you named and they won't have to go through probate. So let's look at Sarah's situation. She has a life insurance policy, a brokerage account, and a retirement account, which already all have named beneficiaries. Her house is owned jointly with her husband. Now, assuming that she passes away before her husband, her probate exposure is very minimal. So a simple, well-drafted will that covers anything that is left over might be all she needs. That said, if her husband passes away before her, the whole situation might change. When she is the last one standing, she is the sole owner of the house and everything else that they owned. So her probate exposure now looks a lot different from when they were a couple. Now let's say Sarah and her husband don't have any children and they really only have a distant relative and a few charities they want to leave things to. They might say, well, we don't care if they have to go through probate and wait a little bit to get what we have, and that would be completely valid. So you see, you might not want to avoid probate altogether in certain situations. And depending on how things might change in the future, maybe you end up having children anyway and you don't want them to go through probate. Then a trust does make sense. Now let's get to factor 2, which is the property structure. Now let's look at Mia. She owns a vacation rental in another state. If that property is sitting alone in her name when she passes away, then her family does not need to go through probate once, but twice in 2 different states. That's called ancillary probate, and that can be avoided with a trust that consolidates everything. Now let's get to my favorite one, factor 3, which is the LLC wrinkle. This one doesn't get talked about nearly enough, and it matters a lot if you own a business. Now let's look at Mia's gelato business. Mia's Gelatos is set up as an LLC. If Mia's ownership sits in her name with no trust involved, that business interest gets frozen in probate along with everything else she owns when she passes away. And plenty of LLC operating agreements require the members of the LLC to approve someone before they become a full voting member. So your child could inherit the economic interest in your business, meaning the money, but without inheriting the authority to actually make decisions in it. And even if Mia has a properly funded trust, meaning that the business is in the trust's name, that doesn't fix this part on its own. A trust does not repair an LLC that was never properly structured for succession in the first place. That's why you need to make sure that all the moving parts, not just your will and your trust, are set up correctly to work together. That's why I set up my estate planning workbook, which you can download for free below, so you can see exactly what the gaps are in your own estate plan. And you can make sure that everything is structured together instead of leaving something that might be frozen by accident. I could create a whole video on how to set up your LLC the right way. If that's something you want to see, make sure you like this video. Now let's move on to factor 4, which is the beneficiary complexity. This is the part where family dynamics come in and where a trust can be very strategic. Let's say Mia has a son who is 18 and she loves him, but she knows that he won't be able to manage a 6-figure account the day he turns 25. Or maybe she has a 30-year-old daughter who is struggling with addiction. Handing her a big lump sum like that might not be the best idea. It might be a risk. In situations like that, you can set up a trust that will hold the money, and that money will be distributed in accordance with the conditions that you set. And you can be very creative with those conditions. For example, Mia can appoint her sister, who she trusts, to be the trustee, and her sister can have the full discretion over the timing of the distributions. Or you could tie those distributions to milestones that you think are important. So for example, Mia's son may receive receive 30% when he turns 25, and then another 30% when he turns 35, and then maybe the remaining 40% when he turns 45. So those are several options you have rather than handing everything over once probate closes. You can also get specific about how money gets divided over several generations. Let's say Mia has her 2 children and she wants, say, 70% of that to go to her 2 children directly. But then maybe she wants the remaining 30% to go to her 3 grandchildren. And then that money will only become distributed to her grandchildren once they turn, say, 30. Now, that structure is very difficult to build with a will alone. That is what a trust is for. And then there is the other angle, which has become more popular over time and I find really interesting, which is the divorce proofing angle. Let's say that Mia has another daughter who is 30 years of age, very responsible with money, but she is now engaged. And Mia is fine with her fiance, maybe not thrilled, but fine. But she has a hunch that this relationship will not last forever. If Mia leaves the inheritance to her daughter outright and she later gets divorced, that money can become part of the divorce settlement. If she leaves it in a trust instead for her daughter, that money stays her daughter's money. So that choice is also up to you, whether you want your son or daughter-in-law to still receive that money even if your daughter or son gets divorced from them, or you can simply divorce proof it. Now let's move on to factor 5, which is privacy. A will becomes part of the public record once it goes through probate. A trust generally stays private. For a lot of people, that alone tips the decision towards a trust. And I know I said there were 5 factors, but there's another factor I should talk about, which is the simplicity versus complexity. A will is largely a set it and forget it mechanism, whereas a trust is not. Going the trust route means that you always need to retitle your home and your investment properties and all your other assets into the trust. So you need to make sure that your future acquisitions also get retitled into the trust's name. Remember the empty box I mentioned earlier? Too many Americans do not retitle their assets into a trust, and then your trust is basically useless. So make sure you review your trust and your assets every once in a while, maybe every year or every 2 years, to make sure that the trust is actually working for you, not against you. So to circle back to the start of this video, your net worth obviously does not decide whether you need a will or a trust. Mia's situation breaks that pretty cleanly. But then not every American needs a trust either. I think Sarah's situation also makes that clear. It comes down to your personal assets, your family dynamics, and your state laws. So what is the next step that you need to take? Well, first download my free estate planning workbook down below. It walks you through all your assets, your family situation, and your goals. And once that is all clear, take your workbook to an estate planning attorney that is licensed in your state and have them set up the right estate plan for you. And if there are any attorneys or financial advisors watching this video, I would love for you to take a look at the workbook and feel free to share that workbook in this video with your clients. And make sure to like this video so it gets pushed out to people who could benefit from watching this.